The highest court in the state ruled at the end of June that farm and ranch employers will have to begin paying into the Workmen's Compensation Insurance Program. The court ruled that an almost 100-year-old provision in state law allowing agricultural employers to opt out of workmen's comp is unconstitutional. Here with me on the line today to talk about this and other topics is Tom Garrity from the Garrity Group PR. Former State Representative Janice Arnold-Jones is here. Sophie Martin, she's an attorney and editor of DukeCityFix.com. And Antoinette Cedillo-Lopez is here. She's Executive Director of Enlace Comunitario. Welcome to all. Before this ruling came down, however, farm and ranch laborers were distinguished from other agricultural employees in an opinion Justice Edward Chavez called, quote, arbitrary discrimination, end quote. Industry groups, however, had argued that forcing workers' comp coverage for these employees would cost agribusinesses, many of them small farms and ranches, tens and tens of millions of dollars. And Sophie, help us understand a little bit what's at stake here. What's the basic foundation here?
So what we're seeing really is an artificial division that was created on farms and ranches between certain types of workers and certain other types of workers. And I think it could be argued that the workers, the laborers who were exempted from workman's comp were those who were least able to sort of provide their own health care. They have very low wages. Yep. They had very little political power to try to affect a change. And so this is a very vulnerable group. And the court looked at cases, two individuals who were injured on the work in an agricultural setting and whose employers did not provide workers' comp for them, and ultimately found that making an artificial distinction between somebody who is a laborer and somebody, say, who is a packager or something else, that it was truly arbitrary, perhaps not entirely arbitrary, given that there were financial incentives to make that distinction, but that it was not based in a meaningful difference between the two groups.
Right.
And because of that, they need to be treated equally. They need to be treated the same. Workman's comp needs to apply to both.
Janice, interestingly, you know, I mentioned in the setup, it's a 100-year-old plus or minus ruling. We had a dissenting opinion. Judge Judith Nakamura said, look, we can't step in front of the legislative process here. We can't make changes unless it comes through that process. Would you agree with her on that?
You know, I actually believe that the legislature makes law, and the courts say this is good or this is not good. Okay. And if they say it's not good, it should go back to the legislature. But that being said, let me just put out on the table, workman's comp is extremely complicated, and I don't think we're getting the bang for the buck, and I don't think we are protecting either the employers or the employees. And even though, and we were talking earlier, that we have set up a way to budget risk, this decision truly, I mean, I can't even argue fairness. How do you divide agricultural workers apart? But the problem comes in the rulemaking. So for agricultural workers, how do you know who is responsible, which employer, especially if they move from farm to farm? None of that was clear in this particular decision. But let me throw in the part that just makes me crazy, and there's a confluence with the ACA and the fact that I personally have worked with several individuals who are under workers' comp, and the doctors will not see them, the hospitals will not treat them, and they must go to court to get medical care. What are we thinking?
Yes, interesting.
Help me here.
Is that right? Exactly. I love that, Janice Arnold-Jones. Interesting. You have someone close to you has been involved in these cases as well. I'm interested in your opinion on this.
Well, it was just funny. My husband was the workers' comp judge. He's not a workers' comp judge anymore, but at the time he issued one of the orders saying you're excluded. That ended up getting consolidated on the path up here. So we've been looking at this for a long time, but it's interesting. Workers' comp is all about helping employers budget risk, and that's what it's about. The court has a constitutional duty, as the third branch, to go in and when the legislature has overstepped its bounds or made an error. And here, treating laborers, treating the person who picks the chilies differently from the person who packs the chilies just made no sense. And when you talk about employers, that this affects employers, it really affects employees, because most employers did have workers' comp. As the court said, only 7% of the industry has over 3 employees, so it's not a huge burden. They had it because most of the big industrial employers have workers' comp because they have to cover the packer.
Gotcha.
So this is just going to affect the individuals who are affected. So I think it was a great decision, a very important exercise of the court's power to put a limit on what the legislature does. And in this case, a truly out-of-date 100-year-old exclusion that really made no sense.
Right, and I'm just going to throw that in there because I don't disagree with you, but I'm here to say that the legislature needs to look at workers' comp because with the advent of the ACA and the way that care is being provided, we are not achieving the goals that we intended, which was to ensure that workers were safe and that they were able to return to work and that there was a benefit when that worker returned to their original employee, that there was a benefit for the original employer. And none of that seems to be working.
Interesting point there. I like that last little bit there. Tom, we're talking about, the numbers are interesting. We're talking about 15 to 20,000 farm and ranch laborers here. We're not talking like in the hundreds. The potential impact here, to be sensitive to the farm owners or ranchers side of things here, we're talking quite a bit of money here at some level.
Absolutely, and you know, I think that my colleagues around the table have done a great job of really kind of framing that whole discussion. There is a whole other conversation though, as far as the potential financial impacts. When you look at 15, 20,000 jobs in New Mexico, that's a lot. I mean, that's a pretty significant number of workers.
That's right.
And when you look at, they're already in a field, no pun intended, where they are looking at, very narrow margins anyway.
Right.
This could dramatically change. Obviously, very positive for the workers. I think 100 years is a little bit too long to not address this. But the farm and ranch industry is really going to have to take a look at their numbers to see just how profitable they're going to be able to be, and that might mean that they might have to cut back somewhere else.
Or prices go down the line. Someone has to pay for this down the line.
Somebody has to be able to pay for it, and we might see it reflected at the store shelf.
That's exactly right. Now, another ruling by the New Mexico Supreme Court overturned a previous district court decision stating that doctors could not be prosecuted for assisting in ending of life of the terminally ill. Now, Sophie, can you help us understand this one, this battle between right to die advocates who oppose assisted suicide, and I really don't like that term, assisted suicide.
And
that's a big turn right there, isn't it?
It's not used as much anymore. So aid in dying is the more prevalent term. And to a certain extent, there's a distinction being made there. And the court, in its ruling on this issue, it seems to me takes some pain to make the distinction, or to at least talk about the difference between suicide and aid in dying, or end of life. That said, the court follows a U.S. Supreme Court ruling that does not say states may not have laws that allow for this, but does say that that the end-of-life decision that is aid in dying is not a constitutionally protected right.
Right.
And I think that there are good arguments on both sides of this. But ultimately, our court, in a unanimous decision, says this is a complicated issue. It is one that really does require a regulatory framework, as we see in the 4 states, or at least 3 of the 4 states that already have aid in dying programs, aid in dying statutes, that this is really, in this case, the job of the legislature to look at the entire framework, and if that body wants to create an aid in dying carve out, then they need to do it thoughtfully.
Janice, I got to go to you again on this one. Interestingly, that idea, that opinion, kicking it back to the legislature to get some clarity on this. The legislature's been down this road already on this issue. So what could we reasonably expect different from the legislature if it does go back to the legislature at this point?
Well, at this time, I'm not sure you were going to see a lot of movement. The question of sanctity of life is going to be forefront should anyone intervene. There is going to be arguments about the ability to take one's own life, whether you are assisted or not assisted. And I think that comes into the category of terminality. And I think you will see a discussion of what is that? what does that mean in our law?
Right.
But I actually, in the next couple of years, because this is such a difficult emotional issue, I don't see a lot of movement yet. I think we're going to kind of wait and see.
Right. But Antoinette, it's, one side, courts are saying, not us, legislature, not us. I mean, what happens to folks who are suffering in the interim?
Sometimes a society's not ready for this dramatic a change.
Right.
And I think one of the concerns that the court raised was how complicated, because there are 4 states now that have an aid in dying statute, some version of it, but they're very complex, detailed things. Like in one state, you have to have 2 written statements or 2 oral statements plus a written statement witnessed by a neutral person who doesn't have to stand to gain. So there's a lot of protection built into those statutes against abuses, so that this fundamental right, or whatever that people are trying to argue for, the courts didn't recognize it in the federal constitution, it didn't see it in the state constitution, and was not ready to go down that road, and felt that if we are going to go down that road, it's the legislature that needs to hash out these really important details.
Tom, this idea of constitutionality, we're not going to settle this at this table, certainly, but the idea if you were suffering a terminal illness and you want to do something with your life and make a decision, a very difficult decision, you don't want to break the law, you don't want to get your doctors in trouble, but at the same time you want to, do you see what I mean? It's a real dilemma for folks now. It's
there's the
difficult.
letter of the law, and then there's the emotion.
Thank you.
And it's very difficult to separate the two.
That's right.
It's a lot easier if you're not necessarily engaged or have ever been engaged in that particular conversation.
That's
I think
right.
a couple of things that I take away from this decision. One is that if people want assistance in ending their life and they want a doctor to help with that, there are options that are available.
Right.
In New Mexico, it was a 5-0. The second thing that jumped out to me was it's a very diverse judiciary, and they all agreed that this is something that is not going to be occurring in New Mexico at this point in time.
Right.
And so and then the other aspect is, the final aspect is that you need to be able to find a way to tell the story. So if you're wanting to get this approved in New Mexico, you're going to have to rely more on the consensus of it all, as opposed to just isolating 1 or 2 stories that are very powerful stories.
Right.
But as long as those who want change are focusing on the individual story as opposed to it's a community issue, I don't think it'll ever move as far as that barometer of change. So to speak.
That's interesting.
It's interesting you bring that up, because in the U.S. Supreme Court case Glucksberg, which dealt with the same issue, there's a place in there where they talk about, there's an opportunity for an individual, for particularized circumstances, to come before the court and argue for themselves. And one of the things I think we see in both of those decisions is a real concern, a real care on the part of the court that someone not be coerced into what may end up not really being a decision for themselves, that people with disabilities be protected, that people who are no longer able to make decisions for themselves be protected. And in the absence of a statutory framework, in Glucksberg, and I think we see also shades of this in this recent opinion in New Mexico, a particular person could come forward and make the case for themselves. And that's very different from what we're sort of used to, which is I represent a larger group, I represent a larger party, or not a larger party, but a larger, like a class of people. And here we see certainly the U.S. Supreme Court saying one person at a time, and we'll see what we can do.
Interesting wrap up there.
It's so unrealistic, though. Someone in this situation is just not in a position to do that.
That's
not
right.
go to court. Thank you.
Right. When we come back to the line, we will talk about the causes and consequences of the recent Doghead fire.